Hi, this is Lee from the Law School Toolbox and the Bar Exam Toolbox. Welcome back to the Listen and Learn series. Today, we will be discussing how a testator can revoke their will. People who execute a will do so because they want to have complete discretion of what happens to their property upon their death. However, just because a testator validly executes a will does not mean they cannot change it if they change their mind. Revoking a will allows a testator to completely or partially change the disposition of their estate. As a reminder, a will can be validly executed if 5 requirements are met. First, the testator must have the requisite capacity, meaning they are of age and have enough mental capacity to understand what they are doing. Second, the testator must have testamentary intent. Third, the will must be in writing. Fourth, the will must be signed by the testator. And finally, fifth, the will must be attested by 2 witnesses, meaning the testator signs the will in the presence of 2 people with the capacity to understand the situation. For a more in-depth discussion on forming and executing a valid will, check out our other Listen and Learn episode that we have linked to in the show notes. Once validly executed, a will can only be revoked in 3 ways. 1. Revocation by a subsequent document. 2. Revocation by a physical act. Or 3. Revocation by operation of law. So let's start with revocation by a subsequent document. A new will that satisfies all of the will requirements I mentioned and contains an express clause that states all previous wills are revoked will revoke a former will in its entirety. If, however, the new will does not contain that express clause that revokes all former wills, then the new will only revokes the old will where the 2 are inconsistent. Now, this might sound complicated, so let's consider an example. Imagine John executes a will leaving $500 to Sam and his residuary estate to Craig. Later, John executes another will that does not contain an express revocation clause. This new will leaves all of his money to Gabby and his house to Amelia. In this scenario, because there was no express revocation clause, the former will is only revoked as to any inconsistencies between the 2 wills. In the first will, $500 was left to Sam, and in the second will, all of John's money was left to Gabby. This is an inconsistency. This means that Gabby will receive all of John's money, and Sam will receive nothing. Because no other inconsistencies exist between the 2 wills, Amelia will receive the house and Craig will still receive the residuary estate. Revocation by a subsequent document does not just apply where there is an entirely new will. It can also apply when there is a codicil. A codicil is an amendment, addition, or supplementation to a will. A codicil is validly executed through the same will requirements and must also express intent to revoke a portion of the will. Because the codicil is an addition and not a full will, a codicil will only partially revoke the existing will to the extent the codicil and the will are inconsistent. Next, a will can be revoked by physical act. A physical act on the will itself can revoke a will if it is done with the intent to revoke the will. These physical acts can include burning, tearing, or destroying the will. It can also be crossing out or drawing on the will. In the majority of jurisdictions, the physical act has to actually touch the words of the will, whereas under the UPC, the physical act does not have to actually touch the words of the will. The physical acts can be done by the testator himself or even by a third party as long as that third party is acting under the testator's instruction and is in the testator's presence while doing it. Revocation by physical act can be both complete and partial, according to the UPC. This means that the physical act does not necessarily revoke the entire will, but can sometimes revoke part of it. If, for example, a testator crosses out a gift to a certain person but leaves the rest of the will intact, UPC jurisdictions will consider this a partial revocation. The crossed-out gift will be revoked, but the rest will remain. As an example, Imagine Carlos validly executes a will in 2004, leaving his car to Sandra and the rest of his estate to Marty. In 2023, Carlos and Sandra got into a huge fight, prompting Carlos to find his will and write in the margins, "I give nothing to Sandra." In the majority of jurisdictions, this would not actually revoke any part of the will. Although Carlos had the intent to revoke his bequest to Sandra due to their fight, Carlos wrote the words in the margins, which means the physical act did not touch the words of the will. In UPC jurisdictions, though, the physical act does not have to touch the words of the will, so this would probably satisfy partial revocation by physical act. The final way to revoke a will is through operation of law. This can be due to marriage, divorce, or the birth of a child after a will was validly executed. The idea is that sometimes a testator will forget to update their will after a major life event happens. It would be unfair to hold the testator to that disposition if they since got married, divorced, or had a child. If the testator gets married after executing their will, that surviving spouse will receive an intestate share of no less than what the spouse would have received had the testator died intestate. This is the case unless it is clear the omission of that spouse was intentional. As an example, imagine Jake executes a will prior to his marriage to Cindy, giving his entire estate to his brother. 10 years after marrying Cindy, Jake validly revokes his will by a new will containing an express revocation clause. This new will gives Jake's entire estate to his sister and makes no mention of Cindy. Likely, this omission of Cindy was intentional because Jake would have included his wife of 10 years in his will if he had wanted to. If the testator gets divorced after making the will, all portions of the will that benefit the ex-spouse will be revoked unless there is clear intent those provisions were meant to survive a divorce. For example, imagine Jake executes a valid will giving half his estate to his wife Cindy and the residue to his daughter. If Jake and Cindy get divorced and Jake fails to execute a new will before his death, Cindy's bequest will be revoked by operation of law. Finally, if a child is born or adopted after their will is executed, the majority of jurisdictions will grant an intestate share to that child. The minority of jurisdictions and the UPC, though, only grant a child born or adopted after the execution of the will an intestate share if the testator had no children when the will was executed. If the testator did have a child when the will was executed, then any child born or adopted after the execution receives a proportional share of that existing child's amount. Let me give you a couple of examples to help this make sense. First, imagine that the testator executed his will in 2000 when he had no children. In 2010, testator had a daughter. Testator died in 2020, never having updated his will. In this situation, the daughter would receive an intestate share of the testator's estate. Now let's change the facts so that in 2000, when the will was executed, testator had a son and gave the son $10,000 in the will. In this situation, the daughter would not receive an intestate share of the testator's estate. Instead, she would receive $10,000 because that is the proportional amount to the son's bequest. Let's work through some examples so you can see how these rules might operate on an exam. First, let's look at a hypothetical adopted from the July 2021 California Bar Exam. In 2016, while single and living in State X, Hank downloaded a will template and filled it out stating, "Because I have no children, I leave all my property to my brother Carter when I die." Hank signed his will in the presence of 2 disinterested witnesses. In 2017, while still living in State X, Hank married Wendy. A daughter, Carly, was born to Hank and Wendy in 2020. In 2021, Hank started a new job. On the first day of his new job, he suffered a fatal injury. What rights do Wendy and Carly have in Hank's estate? Well, what do you think? Would they have any? Let's assume for the purposes of this hypothetical that Hank executed a valid will. A valid will can be revoked if one of three situations occurs. There is no evidence of revocation by subsequent instrument or revocation by physical act here. However, this is a situation of revocation by operation of law. Hank executed the valid will in 2016 when he was single and childless. After executing the will, Hank got married to Wendy and had a child, Carly. We can assume, based on the facts, that Hank unintentionally failed to update his will because he died so unexpectedly. He did not have the chance to update his will, and it might not have been at the forefront of his mind if he was otherwise perfectly healthy. Because Wendy is a new spouse, Wendy will receive a share of Hank's estate that is no less than what she would have received had Hank died intestate. Because Carly is a child born after the execution of the will and is the only child under the UPC and the majority and minority of jurisdictions, she will receive a share equal to what she would have received if Hank died intestate. Hank's brother Carter would receive what is left over. So let's try one more hypothetical. This last hypothetical is adapted from the July 2012 California Bar Exam. In 2004, May, a widow, executed a valid will that intentionally left out her daughter, Dot, and gave 50% of her estate to her son, Sam, and 50% to church. In 2008, after a serious disagreement with Sam, May announced that she was revoking her will and then tore it in half in the presence of both Sam and Dot. In 2011, May died, having never executed a new will. Her sole survivors are Dot and Sam. What rights, if any, do Dot and Sam have in May's estate? Well, here the facts tell us that May's 2004 will was validly executed, so we do not need to analyze the will requirements. In 2008, though, when May tore the 2004 will in half, we have an issue of revocation by physical act. Remember that a testator can revoke a will by physical act if they write over it, burn it, destroy it, rip it up, or cross words out with the intent to revoke the will. The physical act piece is satisfied because May tore the will in half. We can assume this touched the words of the will, so it does not matter which approach this jurisdiction follows. The intent part of this rule is also satisfied. May showed her intent to revoke the 2004 will by announcing to Sam and Dot that she was revoking her will. In addition, her serious disagreement with Sam shows that May might not want Sam to take half of her estate anymore. This means that May validly revoked her 2004 will. Since the facts tell us May never executed a new will, her estate will pass via intestacy, and Dot and Sam will likely split her estate. There was one last important piece of the revocation world you should be aware of, and that is the doctrine of dependent relative revocation. Under this doctrine, a will can still be probated, even if it is validly revoked, either completely or partially. Dependent relative revocation will probate a revoked will if, first, the revocation was based on a mistake of law or fact, and second, if the testator knew the truth, they would not have revoked the will. So let's work through an example to help make sense of this doctrine. Imagine Peter executes a valid will that gives $5,000 to Dre. Later, Peter decides Dre deserves more than $5,000, so he draws a big X on his will and creates a new holographic will, giving Dre $10,000. Unbeknownst to Peter, his jurisdiction does not accept holographic wills. In this situation, Peter validly revoked his will by physical act. He has intent to revoke because he wanted to change the bequest to Dre, and he committed a physical act on the will itself. However, dependent relative revocation will be invoked because, first, Peter revoked this will based on a mistake of law. He thought his holographic will would be valid. And second, had Peter known his jurisdiction did not accept holographic wills, he would not have revoked his original will. Peter wanted to increase Dre's gift, so we can assume he would rather give Dre the original gift compared to no gift. This means that Peter's original will can be probated and Dre would receive $5,000 despite the valid revocation by physical act. We are running out of time, so let me summarize what we have learned. Once a will is validly executed, a testator can revoke that will in one of three ways. First, a testator can revoke a will by subsequent document. This is when a new will or codicil that satisfies all will execution requirements can alter or take the place of an existing will. Second, a testator can revoke a will by physical act. A physical act like burning, tearing, or crossing out can revoke a will completely or partially if it is done with the intent to revoke the will. Third, a testator can revoke a will by operation of law. If a testator gets married, divorced, or has a child after executing a valid will, the will be adjusted to this new life circumstance. However, even if a will is validly revoked through the doctrine of dependent relative revocation, that will can still be probated if the revocation was based on a mistake, and but for that mistake, the testator would not have revoked their will. All right, that's a wrap for today. Glad you could join me as we discussed how to revoke a validly executed will. If you enjoyed this video, please leave us a like, a comment, and subscribe so you don't miss any future content. And you can learn more about what we do at barexamtoolbox.com and lawschooltoolbox.com.